All right, so we're here in the condo in Bloomington. Very nice. They kept this one up really good. Everything's super pristine and clean. Go.
She actually could have been a hero. She could have been a hero. She could have warned Monique.
Wanda Williams Baugh says Monique's 6-year-old recently told her this.
Legend said to me a couple weeks ago, she said that she wants to die. And I said, no, baby, why would you say that? And she said, because I want to see my mommy.
Throughout the proceedings, Segura showed no emotion. As a teen, she survived the 35W bridge collapse. Monique's mother said she did not deserve another chance.
I am asking that she get life without the possibility of parole. No more chances.
Judge Peter Cahill agreed, sentencing her to the same life without parole sentence as Cedric Berry and Barry Davis.
December 31st, 2019. 28-year-old Monique Baugh thought she was showing a house in Maple Grove, Minnesota. Instead, she walked into a trap that would destroy multiple families in a single night. Within hours, Monique was kidnapped from that fake showing. Her boyfriend was shot in front of their 2 young daughters, and Monique's body was found in a Minneapolis alley, executed with 3 point-blank shots to the head. But here's what makes this case even more disturbing. The person who orchestrated this entire nightmare was someone with a grudge over something as trivial as a record label dispute. Drop a comment below. What do you think could possibly justify this level of evil? Because what you're about to watch ID a court case that will leave you speechless.
This is a job that comes with a lot of tragedy. That's something that those of us who do it know, and frankly, in many cases are used to. But there are cases that stand out over the course of your career. This case stands out even among those. Because tragedy as a word doesn't really even touch what happened here and what this family and community has been through, what they will continue to go through every day when they wake up without Monique. And so with that, Judge, we'd ask that you impose the mandatory sentence in this case of life in prison without the possibility of parole.
All right, thank you, Ms. Starkey. All right, Ms. Gadd.
The defense has nothing to add. Thank you.
All right. Anything, does your client wish to make any statements? He certainly has a right to make a statement. I'm happy to hear anything he has to say, or he can choose not to make any statement.
Mr. Wiggins does not wish to make a statement at this time.
Okay, thank you. I want to begin by acknowledging the family members and friends of Ms. Baugh who are here and those who delivered victim impact statements. I do appreciate that. It's helpful for the court to hear from family members in all cases, and I appreciated their efforts to share their views and memories of Ms. Baugh. Mr. Wiggins, as you know, the jury found you guilty of aiding and abetting the murder of Ms. Baugh, her kidnapping, and the attempted murder of John Mitchell Momo. Over the course of the 3-week trial, I did have the opportunity to see and hear all the evidence in this case, and I'm now well aware of the full scope of your criminal conduct. I fully agree with the jury's decision in this case in finding you guilty of those charges. Based on my view of the evidence, it's clear to me that you are the criminal architect of a cold, calculated, and cruel criminal scheme that led to the kidnapping and ultimately to the tragic, senseless, and brutal murder of Ms. Baugh and the attempted murder of Mr. Momo. I guess I'll never fully understand the full reasons behind that, but I don't know that that necessarily matters. Life is precious, but you showed no regard for the lives of Monique Baugh or John Mitchell Momo. You devised and directed the criminal plot that resulted in Ms. Baugh's execution-style murder in a cold and dark alley on New Year's Eve in 2019. Because of you and your co-defendants, 2 little girls will grow up Without their mother and Monique's mother, daughters, friends, family members will never be able to hug her again. I know the sentence I'm imposing today will never fully heal the pain and loss of the family members and friends of the victims. I can only hope that the jury's verdict in finding Mr. Wiggins guilty of these crimes and the sentence I'm imposing today will bring some sense of closure and possibly start the healing process for the loved ones of Ms. Baugh, who lost a daughter, a mother, a granddaughter, a cousin, and a friend. Based on the jury's verdict, Mr. Wiggins, I'll begin with count 3. Based on the verdict of the jury, you are found guilty of aiding and abetting kidnapping to commit great bodily harm under Minnesota Statute 609.25.1, to commit great bodily harm or terrorize. In the judgment of this court, you are convicted of that offense. The court finds that a firearm was used in the commission of this offense. You are committed to the custody of the Commissioner of Corrections for 189 months with credit for 1,981 days. This sentence is to run concurrent with your federal drug sentence. If you have not already provided a DNA sample, you must provide one as required by law. You are prohibited from possessing firearms and ammunition for the remainder of your life. I order that you pay a fine of $50 to be paid from prison wages, and to pay the mandatory surcharge of $78 to be paid from prison wages as well. I'll turn next to count 2. As to count 2, based on the verdict of the jury, you were found guilty of aiding and abetting the attempted murder in the first degree under Minnesota Statute 609.185A1, and the judgment of the court is you are convicted of that offense. The court finds that a firearm was used in the commission of this offense. You are hereby committed to the custody of the Commissioner of Corrections for 240 months with credit for 0 days served. This sentence is consecutive to the sentence already imposed for count 3 and any other sentences imposed. Again, a DNA sample is required, and you are prohibited from possessing firearms and ammunition for the remainder of your life. Turning finally to count 1. Based on the verdict of the jury, you are found guilty of aiding and abetting murder in the first degree under 609.185A1, and the judgment of this court is that you are convicted of that offense. The court finds that a firearm was used in the commission of that offense. You are committed to the custody of the Commissioner of Corrections for the remainder of your life with credit for 0 days served. This sentence carries with it no possibility of release or parole. This sentence is consecutive to the sentences already imposed for counts 3 and count 2 and any other sentences already imposed. Count 4 shall remain unadjudicated pursuant to Minnesota Statute 609.04 as a lesser included offense of count 1. Again, in count 1, you need to provide a DNA sample as required by law, and again, you're prohibited from possessing firearms and ammunition for the remainder of your life. I will order restitution to be paid consistent with the previous restitution order. Ms. Gadd, have you seen that restitution order?
I've seen the amount on the docket, but I haven't seen the order itself.
And Mr. Filipski did just email both the court and counsel an updated proposed copy.
Any objection to the restitution order, Ms. Gadd?
Give me just one moment to review it. No objection.
All right, I will order restitution and make a finding that Mr. Wiggins does have the ability to pay. The funds will be taken out of prison wages. There are two amounts. One is $11,917.88. The other is $61,489.88. Is that the order that you received, Ms. Gadd?
Yes, that's the one that Mr.
So I think I have to re-execute this. This is a new sentence, so I will sign this order today, ordering the restitution in those amounts. And I will date it today's date. All right. Anything further?
Nothing.
Either party.
Thank you, Your Honor.
Nothing for the defense. I did file a motion to withdraw as counsel. But I'm not sure if Your Honor wants to address that today or after today.
I can maybe address it later.
Okay.
After today? I think I did not see that, so I didn't. Why don't I look at it and then I can address it after this hearing?
Absolutely.
Okay. All right. Thank you.
Good morning. We are here to address today's guilty plea by Elsa Segura in her role in Monique Baugh's murder. I want to acknowledge how difficult having this case reopened by the Minnesota Supreme Court has been for the Baugh family. And I want to express my deepest condolences to all of you in the back there. Part of our team's reasoning for settling this case without trial is to prevent that from happening again, while obtaining a sentence that reflects Ms. Segura's role in this absolutely horrific crime. On New Year's Eve 2019, Minneapolis realtor Monique Baugh had what she thought was a routine home showing for a property in Maple Grove. Elsa Segura had been calling and texting her using a different name, expressing interest in viewing a home for sale. But Elsa Segura wasn't interested in buying the house. What was supposed to be a quick showing before ringing in the new year quickly took a turn for the worst. Segura was one of 5 people involved in a larger plan to kidnap Ms. Baugh. They abducted her and confined her in the cargo hold of a moving truck. They drove Ms. Baugh to her home and used her house key to enter and shoot her boyfriend multiple times in the presence of their 2 little girls. Ms. Baugh's boyfriend was seriously injured but survived and managed to call for help. About an hour later, Monique Baugh was found with 3 gunshot wounds in an alley near her home. 5 people were charged in connection with her murder. In 2021, a jury convicted Ms. Segura on various aiding and abetting theories, and the judge sentenced her to life without the possibility of parole. On January 31st, 2024, the Minnesota Supreme Court remanded, or essentially returned, her case to Hennepin County because they said there was insufficient evidence to support the aiding and abetting premeditated murder convictions. Her other convictions, kidnapping and felony murder, were returned to Hennepin County because of erroneous jury instructions. Today, Ms. Segura pled guilty to kidnapping, and the judge sentenced her to 240 months in prison. The presumptive guideline sentence for kidnapping is actually 86 months. The plea agreement called for an upward departure from state sentencing guidelines based upon the particular cruelty of the crime and the involvement of 3 or more perpetrators. Of the other co-defendants involved in Ms. Baugh's murder, 2 are in prison serving life sentences without hope of parole. 1 served probation, and the 5th person is awaiting a retrial. He has an appearance later this week. Ms. Baugh was a mother of 2 girls, ages 1 and 3 at the time. She loved to read stories to her children, and she had a special purple pillow she would lie on to read to them. Co-workers described Ms. Baugh as compassionate, driven, and someone who would do anything to protect and provide for her children. Monique Baugh had a bright future ahead of her. Now her loved ones will never get to experience Ms. Baugh's wonderful sense of humor again. Ms. Baugh's children, who lost their mother so young, will grow up without memories of their mother that they can call their own. This is an incredibly sad tragedy that absolutely did not have to happen, and my heart is with Ms. Baugh's family and loved ones. I do want to thank our trial team who have handled this case, Paige Starkey and Chris Filipski behind me. Paige was tried the original case, and I know has worked incredibly hard on this to make sure that justice is done. Questions?
Regarding the aiding and abetting premeditated murder ruling, can you explain what exactly that means that the Supreme Court says and how that affected this case and potentially other cases?
So generally, aiding and abetting requires that someone knows that the crime is going to be committed or should have known. So in other words, you know that there's going to be a murder or you should have known. And the Supreme Court felt that we had not presented enough evidence to convince them that there were no other alternative theories. In other words, could she have thought something else was going on here? And in fact, I think they specifically said it could have been some less serious crime. She, I think, claimed that she thought it was about drugs. So essentially what the Supreme Court was saying is that there was not enough evidence to convince them that she knew her participation was going to lead to a murder or would aid and abet a murder.
So then for the Wiggins case, even though they made the same kind of ruling, the facts of what's going on in his mind might be different than what were going on in her mind? Is that?
Absolutely.
Okay.
Absolutely.
So
Yes.
So
It's very
what's going to happen with this? Yeah, explain that and then what's going to happen with this case.
It's very fact specific. In fact, we believe that Wiggins was the mastermind here, and we will proceed to trial if we need to on that case, because we believe that he masterminded this entire thing, even though he did not fire the shots that killed Ms. Baugh.
How about Barry and Davis? Will that affect our cases at all?
They are both, Paige, I'm going to have Paige Starkey answer that. They're both.
Both Barry and Davis have appealed. Their convictions have been upheld by the Minnesota Supreme Court.
I should also say, I said at the beginning that it was very difficult, I know, for the family to have this reopened. Anytime there's a trial, there's probably going to be an appeal. But when someone pleads guilty, there can be an appeal, but people are very unlikely to prevail. So we would consider this the end of Ms. Segura's case.
One more big picture
Yep.
question. So moving forward with future cases where there ends up being a murder, will this ruling potentially prevent you from charging based on the ultimate results?
We always look at each case individually, and in each case there are different facts that may or may not support an aiding and abetting theory. I don't think it'll change our approach other than to analyze the individual facts to see if we think that fits what the Supreme Court is looking for. But we will always look at each individual case because each case is unique and it has its own facts. Thank you.
I just have one last question. I found that there were 4 people involved here. Who's the 5th?
So there was a woman, do you want to go?
So the fifth person whose sentence ultimately was probation was Shantae Barry, Cedric Barry's wife, and Barry Davis's sister. And so she was convicted of aiding an offender for her role in assisting with parts of kind of the cover-up and lying to investigators.
Thank you, everybody.
Thank you.